All names, places, and institutions are aliases used to protect privacy. Procedures and timelines reflect real-world law and forensics for immersion. The hearing room on the 5th floor of the Granite County Courthouse had grown dark by the time the last exhibit landed on the judge's bench. Outside the tall windows, streetlights flickered on, casting amber bands across the gallery where 24 spectators sat in near silence. At the defense table, a man named Rook pressed his palms flat against the wood, fingers splayed, feeling the grain beneath his skin. 20 years had passed since he last sat in this building as anything other than a number, and now, at 43, he watched Judge Keystone lift a manila folder and angle it toward the overhead light. The folder contained 3 cassette tapes. Not the originals, those had been digitized twice over, but certified copies, each bearing evidence stickers and chain of custody stamps that stretched back 2 decades. On those tapes, voices rose and fell in a rhythm Rook had tried to forget. His own, exhausted and disoriented, and the steady, insistent cadence of Detective Harbour, who had questioned him for 11 hours in a windowless room without recording the first 8. The recordings that did exist, captured only after Harbour's partner insisted on compliance with new department policy, had sat in an evidence vault for years, filed under case number and buried beneath hundreds of other boxes. Until 3 months ago, when an attorney named North, working with the Riverbend Innocence Project, had petitioned for a full evidentiary review and unearthed what the original defense had never heard, the unmistakable sound of a confession unraveling under pressure. Rook's eyes moved to the gallery, where his sister sat in the second row, hands folded in her lap. She had driven 6 hours from the coastal city of Harborview, taking unpaid leave from her nursing shift to be here. He had missed her wedding, the birth of her 2 children, and their mother's funeral. All of it, 20 Christmases, 20 springs, 20 cycles of parole hearings that ended in the same cold refusal because a jury had believed that he killed a man named Victor in an alley behind a shuttered textile mill on a January night when snow turned to sleet and sirens echoed off brick. The crime scene itself had been stark. Victor, a 41-year-old line supervisor at the mill, found face down on gravel-dusted asphalt, his skull fractured, wallet missing. First responders arrived at 11:47 p.m., called by a security guard who had heard shouting. Blood pooled around the victim's head, mixing with runoff from melting snow. The medical examiner would later testify that Victor died from blunt force trauma, consistent with a pipe or similar object, though no weapon was recovered. 2 cigarette butts lay near the body, 1 menthol, 1 unfiltered, and a single sneaker print, size 11, pressed into a patch of mud 6 feet away. Physical evidence collection followed standard protocol. Photographs from multiple angles, measurements recorded in a scene sketch, items bagged and tagged by a forensic technician named Crest. The evidence was transported to the Arcadia State Crime Lab, where it would sit in a queue for weeks before processing. Rook had been 17 at the time, living in a rented room above a diner 3 blocks from the mill. He had no prior record, worked part-time stocking shelves, and had known Victor only by sight. The man sometimes came into the diner for coffee during shift breaks. But on the night of the murder, Rook had been walking home from a friend's apartment, cutting through the industrial district because the buses had stopped running. A patrol officer spotted him on Mill Road at 11:52 p.m., 5 minutes after the 911 call, and noted in his report that Rook appeared agitated, walking quickly with his hands in his pockets. When officers canvassed the area 2 days later, they found Rook's name in the diner's employee log and brought him in for questioning. If you've ever wondered how a case that seemed so certain can collapse under the weight of its own contradictions decades later, stay with this story and consider subscribing so you don't miss the conclusion. Detective Harbour had been with the Granite County Sheriff's Department for 12 years when he caught the Victor homicide. He was known for closing cases, for building narratives that held together in court, and for his ability to read a suspect's body language across a metal table. When Rook arrived at the station on a Wednesday morning, escorted by 2 uniformed officers, Harbour had already assembled a file. The sneaker print, witness statements placing Rook in the vicinity, and a hunch that the young man's nervousness signaled guilt rather than fear. The interrogation began at 9 a.m. in interview room 3, a windowless space with cinder block walls painted institutional beige and a metal table bolted to the floor. For the first 3 hours, Rook maintained his account. He had been walking home, heard nothing, saw nothing. Harbour pressed on timeline inconsistencies. Why had Rook taken the long route through the industrial district instead of the direct path along Cedar Street? Rook explained that Cedar had been dark, unlit, and he preferred the mill route because streetlights made him feel safer. Harbour suggested that Rook had argued with Victor over money, that things had escalated, that a moment of panic had turned into tragedy. Rook denied it, his voice steady at first, then cracking as hours passed without food, without water, without a lawyer he did not know he could demand. At noon, Harbour left the room for 20 minutes. Rook sat alone, handcuffed to a ring on the table, staring at the two-way mirror. He asked for water when Harbour returned. Harbour said they would get to that. First, he needed Rook to be straight with him. At 2:00 p.m., Harbour's partner, Detective Vale, entered the room and reminded Harbour of the new recording policy implemented by the department 6 months earlier. All interrogations of primary suspects must be audio recorded. Harbour waved him off, said they were still in the preliminary phase, that Rook was cooperating voluntarily. But Vale insisted, citing Department General Order 04-16, which mandated recording to protect both suspects and officers from allegations of misconduct. Harbour relented, but not until 5:00 p.m., 8 hours into the session, when he finally switched on the cassette recorder mounted on a shelf behind the table. What followed, captured on 3 90-minute tapes, was a study in incremental collapse. Rook's voice on the tapes sounded thin, almost mechanical. He repeated fragments of Harbour's questions, agreeing with hypotheticals, nodding when the recorder could not capture the gesture. Harbour's tone remained calm, paternal even, offering reassurance that the truth would set things right, that cooperation would be noted by the prosecutor, that everyone understood accidents happen. At one point, Harbour leaned forward and said, "Look, Rook, I know you didn't mean to hurt him. Things got out of hand. Victor pushed you, right? You pushed back. That's not murder. That's just bad luck." Rook said nothing for a long moment, then whispered, "I don't know what happened." Harbour seized on the ambiguity. "You were there, though. You saw what happened." Rook, after another pause, said, "I was walking home. I saw him on the ground." Harbour, "You saw him fall?" Rook, "I don't know." Harbour, "But you were there when it happened." Rook, finally, in a voice barely audible, "I guess." By 8 p.m., Rook had signed a statement, handwritten by Harbour, reviewed by Rook, initialed on each page, that placed him at the scene, admitted to an argument over $20 Victor had borrowed and never returned, and described a shove that caused Victor to fall backward, striking his head on the pavement. The statement contained no mention of a pipe, no stolen wallet, no explanation for the sneaker print, which was 2 sizes larger than Rook's size 9 shoes. But it was enough. The statement was typed up by a department secretary and presented to Prosecutor Slate the following morning. Slate reviewed it, noted the confession, and authorized charges. 2nd-degree murder. Rook was arraigned that afternoon, represented by a duty public defender who had 30 seconds to speak with him before the judge called the case. Bail was set at $500,000. Rook's family could not raise even the 10% required for a bond. He was remanded to the Granite County Jail to await trial. The trial took place 9 months later in the same courthouse where Judge Keystone now presided over the post-conviction hearing. The prosecutor, Slate, built a straightforward case. Motive, opportunity, confession. Slate called Detective Harbour to the stand, who testified about Rook's nervousness during the walkthrough of the scene, his shifting explanations, and his eventual admission of responsibility. Harbour described Rook's demeanour as evasive, said the young man had avoided eye contact, had fidgeted with his hands, had grown increasingly agitated as the interview progressed. On cross-examination, the defence attorney, a court-appointed public defender named Frost, asked Harbour how many hours the interrogation had lasted. Harbour said 11. Frost asked how many of those hours had been recorded. Harbour said 3. Frost asked why the first 8 hours had not been recorded. Harbour explained that the recording equipment had been occupied with another case and that he had complied with policy as soon as equipment became available. The tapes were played for the jury, only the recorded portions, starting at hour 8. And the jurors leaned forward in their seats, listening to Rook's voice agree again and again that he had been there, that he had argued, that Victor had fallen. The tapes ran for nearly 4 hours, including long silences where Rook said nothing, and Harbour waited, patient and unyielding. At one point on tape 2, Harbour said, "I'm trying to help you here, Rook. If you don't cooperate, the DA is going to throw the book at you. You're 17 now, but you'll be tried as an adult. That's life without parole. But if you help me understand what happened, if you show remorse, the judge will see that. You'll get a second chance." Rook's response after a 30-second pause, "I just want to go home." The defense attorney, Frost, was in his second year of practice. He challenged the confession on constitutional grounds, arguing that 11 hours without counsel, without food, without meaningful breaks violated Rook's rights under Miranda versus Arizona. But the recorded portion began after Miranda warnings had been administered, and Rook had waived his rights on tape, his voice flat as he said, "I understand." Frost also pointed to the sneaker print and the missing weapon, suggesting that another assailant had been present. He called a forensic expert named Dr. Flint, who testified that the print's size and tread pattern were inconsistent with Rook's shoes, and that the absence of blood spatter on Rook's clothing was inconsistent with close-range blunt force trauma. Slate countered that the print could have come from anyone, a passerby, the security guard, even a first responder, and that Rook could have changed his clothes before police contacted him. Slate also pointed out that Rook's statement described a shove, not a beating, which would explain the lack of blood spatter if Victor had struck his head on the pavement rather than being struck with an object. The jury deliberated for 6 hours. They returned a verdict of guilty on second-degree murder. Judge Keystone, then a newly appointed circuit judge, sentenced Rook to 25 years to life, noting the defendant's age, but emphasizing the severity of the crime and the need for public safety. Rook's sister had screamed from the gallery, a raw, animal sound that bailiffs had to silence as they led Rook away in handcuffs. She collapsed in the corridor outside, sobbing into her hands, while Frost gathered his files and left without a word. Inside Riverbend State Correctional Facility, Rook learned the rhythms of incarceration. Count time at 6 a.m., breakfast at 6:30, work assignments at 7, lunch at noon, recreation yard from 2 to 4s, dinner at 5s, count time again at 9 noons, lights out at 10 noon. He worked in the laundry for 7 years, standing at industrial washers that roared like jet engines, loading sheets and jumpsuits and towels that came out scalding and damp. He burned his hands more than once, learned to grip the fabric at the edges, learned to move quickly so the line kept pace. After 7 years, a counselor moved him to the library, where he shelved books and helped other inmates prepare legal filings. He read case law, learned the language of habeas corpus and ineffective assistance of counsel, and filed his first direct appeal within a year of sentencing. The appeal was denied. Frost had raised the confession issue, the sneaker print, the lack of physical evidence tying Rook to the murder weapon, but the appellate court, in a terse opinion, held that the trial court had not abused its discretion in admitting the confession, that the jury had been entitled to weigh the credibility of the evidence, and that no constitutional violation had been clearly established. The tapes had been played. The process had been followed. Rook filed a second appeal, this time pro se, arguing that Frost had provided ineffective assistance by failing to call additional witnesses and by not challenging the chain of custody for the physical evidence. That appeal was also denied. He wrote letters to his sister every week, filling lined notebook pages with small, careful handwriting. She responded when she could, sending photos of her children, updates on family events, and occasional money orders for the commissary. She visited once a month, driving 6 hours each way, sitting across from him in a visiting room that smelled of disinfectant and sweat. They spoke through a plexiglass partition, using phones that crackled with static. She told him about her wedding. She had married a mechanic named Paul, a quiet man who treated her well. She told him about the birth of her daughter, then her son. She told him about their mother's declining health, the dementia that erased names and faces, the stroke that finally took her on a Tuesday morning in March. Rook had filed a compassionate release request to attend the funeral, but it was denied on grounds that he posed an escape risk. What Rook did not know, what no one knew for years, was that the unrecorded first 8 hours had contained something different. In Detective Harbour's original handwritten notes, filed in a storage annex and never turned over to the defense, Harbour had documented his interrogation strategy in detail. The notes, written in blue ink on a yellow legal pad, filled 6 pages. On page 3, Harbour had written, "Subject maintains innocence, refuses to engage hypothetical scenarios, suggested consequences of non-cooperation, emphasized leniency for cooperation. Subject appeared confused, requested call to sister multiple times, denied pending completion of interview." On page 5, subject showing signs of fatigue, repeated question timeline discrepancy, subject now uncertain of own account, progress. On page 6, subject agreed to hypothetical scenario, statement drafted and signed, recommend charging as adult, confession obtained, physical evidence circumstantial but supportive. Under Brady v. Maryland, prosecutors are required to disclose evidence favorable to the defense, including materials that could impeach the credibility of key witnesses or undermine the prosecution's case. Exculpatory evidence includes anything that tends to negate guilt, reduce culpability, or cast doubt on the reliability of the prosecution's evidence. But Harbour's notes had never been classified as Brady material because they were labeled as investigative work product, internal documents not subject to disclosure. Prosecutor Slate had never reviewed them. Frost had never requested them, assuming that all relevant materials had been turned over during discovery. The turning point came in the 19th year of Rook's sentence, when a newly hired paralegal at the Riverbend Innocence Project, a woman named Cedar, began combing through old case files as part of a statewide initiative to identify wrongful convictions involving potentially coerced confessions. The initiative had been launched in response to a landmark study by the National Registry of Exonerations, which found that false confessions contributed to approximately 12% of wrongful convictions nationwide, with rates significantly higher for juveniles and young adults. Cedar had been trained to look for specific markers: juveniles interrogated without guardians, interrogations exceeding 10 hours, unrecorded pre-Miranda questioning, and cases where confessions contained details inconsistent with crime scene evidence. Rook's case flagged on 3 counts: 17 years old at the time of arrest, 11-hour interrogation with only 3 hours recorded, and a confession that described a shove rather than the blunt force trauma indicated by the autopsy. Cedar brought the file to Attorney North, a former prosecutor who had switched sides after witnessing a false confession case unravel during her tenure in the district attorney's office. North had been present when a man named Ellis, convicted of armed robbery based on his confession, was exonerated after surveillance footage surfaced showing him in another city at the time of the crime. The confession had been false, the product of a detective's insistence that cooperation would lead to leniency and that failure to confess would result in a life sentence. North had left the DA's office 6 months later and joined the Innocence Project, determined to undo the damage she had once helped inflict. North reviewed the trial record, noted the absence of the first 8 hours of interrogation from any recording, and filed a Freedom of Information Act request for all investigative materials related to the Victor homicide. The Granite County Sheriff's Department initially denied the request, citing ongoing investigative interests and privacy concerns. North filed a motion to compel, and after 6 months of litigation, a judge ordered the department to produce all materials. The documents arrived in 4 banker's boxes, delivered to North's office on a Friday afternoon. She spent the weekend reviewing them, working through the night with Cedar, sorting reports and photographs and evidence logs. On Sunday morning, at the bottom of Box 3, she found Harbor's yellow legal pad. When North read the notes, she felt the familiar tightness in her chest that came with uncovering a buried truth. Harbor had documented the very techniques that courts had later recognized as coercive: prolonged isolation, repeated denials of requests to contact family, and the use of minimization tactics that suggested leniency in exchange for a confession. More importantly, the notes revealed that Rook had never wavered in his denial of guilt until hour 10, after Harbor had suggested that the prosecutor might charge him as an adult and seek a life sentence without parole. The notes also contained a detail that had never appeared in the trial record. At hour 7, Rook had asked if he could take a polygraph test to prove his innocence. Harbor had written, "Declined polygraph request, unreliable and not admissible. Subject believes test would exonerate him, suggests genuine belief in own innocence or sophisticated deception." North filed a motion for post-conviction relief under State Code Section 78-421, which allows defendants to challenge convictions based on newly discovered evidence that could not have been obtained with due diligence at the time of trial. The motion argued that the confession had been coerced, that the state had violated its Brady obligations by failing to disclose Harbor's notes, and that the totality of circumstances, Rook's age, the length of the interrogation, the absence of counsel, and the use of minimization tactics rendered the confession involuntary under the 5th and 14th Amendments. North also requested a full evidentiary hearing, where Harbor and other witnesses could be called to testify under oath about the interrogation and the evidence. Judge Keystone, who had presided over the original trial, granted the hearing, an unusual move, but one supported by recent changes in state law that expanded the grounds for post-conviction review in cases involving newly discovered evidence of constitutional violations. Before the hearing, North took an additional step. She petitioned for DNA retesting of the cigarette butts found at the scene. At the time of the original investigation, the Arcadia State Crime Lab had used RFLP typing, a method that required relatively large samples and produced profiles with limited discriminatory power. The cigarette butts had yielded only partial profiles, insufficient for comparison to Rook or any database entry. But advances in DNA technology, specifically the advent of short tandem repeat analysis, capillary electrophoresis, and more sensitive extraction protocols, now allowed for testing of degraded or limited samples that would have been unusable 20 years earlier. North retained a private forensic laboratory, Biotrace Solutions, to perform STR analysis on the remaining biological material. The testing took 8 weeks. The results arrived in a sealed envelope, delivered by courier to North's office on a Tuesday morning. She opened it alone in her conference room, hands steady, and read the report twice before calling Cedar. The DNA profile extracted from the unfiltered cigarette butt excluded Rook with a statistical certainty of 99.99997%. The profile matched a man named Hayes, whose DNA had been entered into the state database 5 years earlier following a conviction for aggravated assault. Hayes had been questioned during the original investigation. His name appeared in Harbour's notes as a known associate of Victor's, but he had provided an alibi and been released. The alibi, according to the file, was that Hayes had been at a bar called The Anchor, 5 miles from the crime scene, from 10 p.m. until closing at 2 a.m. 2 witnesses, both regulars at the bar, had corroborated the alibi in brief statements taken by a patrol officer. North requested the complete investigative file on Hayes and discovered that the alibi had never been rigorously tested. The 2 witnesses had not been interviewed in depth. Their statements consisted of single sentences, and no attempt had been made to obtain surveillance footage, receipts, or other corroborating evidence. More troubling, Hayes wore size 11 shoes, the same size as the sneaker print found at the scene. North filed a supplemental motion requesting that the court consider the DNA evidence alongside the coercion claims. The hearing began on a Thursday morning in late autumn, the air cool and sharp. Rook sat at the defense table in civilian clothes for the first time in 2 decades, khakis and a button-down shirt his sister had brought to the jail the night before. North sat beside him, flanked by Cedar and a forensic psychologist named Dr. Ember, who specialized in false confessions and had testified in more than 40 post-conviction cases. The gallery was half full, mostly journalists and law students from the nearby university, along with Rook's sister and a handful of advocates from the Innocence Project. The first witness was Detective Harbour, now retired, his hair gone white, his hands trembling slightly as he took the oath. Prosecutor Slate, still in the office after all these years, conducted the direct examination. Harbour testified that he had followed standard procedures for the era, that Rook had been offered food and water at various points, and that the confession had been voluntary. Slate asked whether Harbour had coerced the defendant in any way. Harbour said no, that he had simply asked questions and allowed Rook to tell his story. Slate asked about the decision to delay recording. Harbour explained that the department had limited recording equipment at the time, that other interviews had been ongoing, and that he had begun recording as soon as a cassette recorder became available. North rose for cross-examination. She was methodical, almost surgical, her questions short and precise. She entered the handwritten notes into evidence as Defense Exhibit A, handing Harbour a certified copy. Harbour did not deny writing them. North asked him to read aloud the passage where he had noted Rook's repeated requests to call his sister. Harbour read it, his voice flat. Subject appeared confused, requested call to sister multiple times, denied pending completion of interview. North asked, "Why did you deny those requests?" Harbour paused. "I wanted to finish the interview first, to avoid outside interference that might compromise the integrity of the statement." North, did you consider that a 17-year-old held for 11 hours without contact with family or legal counsel might agree to a statement just to end the interrogation? Harbour, I considered that he was guilty. North, did you consider that he might not be guilty? Harbour, the evidence suggested otherwise. North, what evidence? The sneaker print that didn't match his shoes, the murder weapon that was never found, the wallet that was never recovered. Slate objected. Argumentative. Judge Keystone sustained the objection, but allowed North to continue. She introduced the tapes next, playing a 15-minute segment from tape 2, where Rook's voice, drained and defeated, repeated Harbour's words almost verbatim. The courtroom was silent, except for the hiss of the cassette player and the sound of Rook saying, "I guess," and "I don't know," and "if you say so." North called Dr. Ember, who took the stand with a thick binder of peer-reviewed studies and case reports. Ember explained the psychology of compliance in detail, describing how exhaustion, fear of worse outcomes, and authority figures' promises of leniency can override an innocent person's self-interest and lead to false confessions. Ember testified that false confessions occur more frequently than the public realizes, citing the National Registry of Exonerations data showing that approximately 15 to 20% of DNA exonerations involved false confessions. Ember also described the Reed technique, a widely used interrogation method that employs psychological pressure, minimization of moral culpability, and suggestions of leniency to elicit confessions. Ember noted that the technique, while legal, has been criticized for its potential to produce false confessions, particularly when used on juveniles or individuals with cognitive impairments. Ember reviewed the transcripts of Rook's interrogation and identified multiple Reed technique tactics: theme development, where Harbour constructed a narrative of accidental violence; minimization, where Harbour suggested that Victor's death was the result of bad luck rather than intent; and maximization, where Harbour warned of life imprisonment if Rook did not cooperate. Ember testified that these tactics, combined with the length of the interrogation and Rook's age, created a coercive environment that likely overwhelmed his ability to resist falsely confessing. On cross-examination, Slate challenged Ember's conclusions, asking whether it was possible that Rook had confessed because he was guilty. Ember conceded that false confessions are not the only explanation for admissions of guilt, but emphasized that the specific circumstances of Rook's interrogation, the length, the techniques, the absence of recording for the first 8 hours, were consistent with coercion. Slate asked whether Ember had interviewed Rook personally. Ember said no, that her analysis was based on the documentary record. Slate suggested that without a personal evaluation, Ember could not definitively conclude that the confession was false. Ember replied that her role was not to determine factual guilt or innocence, but to assess whether the interrogation methods were likely to produce a false confession, and that, in her expert opinion, they were. The second day of the hearing focused on the physical evidence. North called forensic analyst Juniper, who had worked at the Arcadia State Crime Lab during the original investigation and was now retired. Juniper testified that she had tested the cigarette butts found at the scene using RFLP typing, which at the time was the standard method for DNA analysis. The butts had yielded only partial profiles, insufficient for comparison to Rook or any database entry. Juniper explained that RFLP required high-quality, high-quantity DNA samples, and that the butts had been exposed to rain and environmental degradation, which compromised the samples. North asked Juniper whether advances in DNA technology might allow for retesting of the samples. Juniper confirmed that STR analysis, which became widely adopted in the late 1990s, was significantly more sensitive and could produce profiles from degraded or limited samples that RFLP could not. North introduced the Biotrace Solutions report as Defense Exhibit C, and Juniper reviewed it on the stand. The report showed that STR analysis had successfully extracted a complete DNA profile from the unfiltered cigarette butt, and that the profile matched Hayes with a probability of random match of 1 in 7 billion. Juniper confirmed that the profile excluded Rook as a contributor. North asked, "In your expert opinion, does this DNA evidence suggest that someone other than the defendant was present at the crime scene?" Juniper hesitated, then said, "It suggests that Hayes was present, and that he smoked a cigarette near the location where the victim was found. It does not conclusively prove that Hayes committed the murder, but it is consistent with his presence at or around the time of the crime. No, prosecutor Slate objected, arguing that the cigarette butts could have been discarded at any time, that their presence did not prove Hayes killed Victor, and that smokers often discard cigarettes in public areas. Slate pointed out that the crime scene was near a loading dock where workers took breaks, and that the butts could have been left days or even weeks before the murder. North countered with the sneaker print, size 11, consistent with Hayes's shoe size as documented in his booking record, and inconsistent with Rook's size 9 shoes. North also noted that the sneaker print was found in mud, not on dry pavement, which suggested it had been made on the night of the murder when snow had melted into slush. Slate had no rebuttal beyond reiterating that the print was circumstantial. The final witness was Detective Vale, Harbour's former partner, who had insisted on starting the recording at hour 8. Vale took the stand with visible reluctance, his posture stiff, his answers measured. He testified that he had been uneasy about the length of the interrogation, that he had seen Rook slumped in his chair with his head on the table, barely responsive. Vale said he had filed an internal memo expressing concerns about the tactics used, specifically the denial of Rook's requests to contact his sister and the use of hypothetical scenarios that Rook appeared to accept out of confusion rather than genuine agreement. The memo, Vale testified, had been reviewed by a supervisor named Lieutenant Grimes, who dismissed the concerns and noted that Rook had signed the statement voluntarily and that the interrogation had complied with department policy once recording began. North asked Vale, "In your opinion, was the confession voluntary?" Vale paused for a long moment, then said, "I don't know. At the time, I thought we had the right guy. Looking back, I'm not sure." Judge Keystone called a recess at 4:30 p.m. The gallery emptied slowly, spectators murmuring to one another, journalists tapping notes into laptops. Rook sat motionless, staring at the wall, hands folded on the table. North placed a hand on his shoulder and said nothing. There was nothing left to say, only to wait. When court reconvened the next morning, Judge Keystone spoke for 31 minutes. He reviewed the law on coerced confessions, citing Miranda v. Arizona, Colorado v. Connolly, and a recent state Supreme Court decision, State v. Marlowe, which held that confessions obtained through prolonged interrogation without adequate safeguards could be deemed involuntary even if Miranda warnings were eventually administered. He noted that the failure to disclose Harbour's notes constituted a Brady violation, as the notes contained impeachment material that could have undermined the prosecution's case by showing that Rook had maintained his innocence for the majority of the interrogation and had only begun to waver after explicit threats of life imprisonment. Judge Keystone acknowledged that the new DNA evidence, while not conclusive on its own, created reasonable doubt when considered alongside the coerced confession and the absence of physical evidence tying Rook to the crime. He noted that the sneaker print, which had been dismissed at trial as ambiguous, now took on greater significance in light of Hayes's DNA being found at the scene and Hayes's shoe size matching the print. Keystone also addressed the procedural history, noting that Rook's original defense attorney had failed to challenge the interrogation with sufficient vigor and had not requested a complete investigative file, which might have uncovered Harbour's notes. Judge Keystone's voice was measured but firm as he concluded, "The confession that formed the cornerstone of the state's case was the product of coercion, obtained through prolonged interrogation of a juvenile without counsel, without adequate breaks, and through the use of minimization and threat tactics that are now recognized as inherently coercive. The physical evidence now suggests that another individual may have been responsible for the victim's death, and the state's failure to disclose exculpatory impeachment material violated the defendant's constitutional rights. The defendant's conviction cannot stand. The verdict is vacated and the charges are dismissed. He struck his gavel once. The sound echoed through the courtroom like a gunshot. Rook stood, and for a moment he did not move. Then his sister was beside him, arms around his neck, sobbing into his shoulder. North shook his hand, then hugged him, something she rarely did with clients. Judge Keystone left the bench without ceremony, and the courtroom emptied into the cold evening air. Rook walked out through the front doors, not the side entrance reserved for prisoners, and stood on the courthouse steps as the sun set behind the buildings across the square. The logistics of release took 3 days. Rook's records had to be updated in the state corrections database, his fingerprints rescanned, his identification reissued. He was photographed again, this time without the inmate number placard. The state offered no apology, only a standardized letter acknowledging the vacated conviction and noting that he was free to pursue compensation through civil proceedings. North filed the paperwork anyway, initiating a claim under the state's Wrongful Conviction Compensation Act, which authorized payments of $50,000 per year of wrongful incarceration, subject to proof of actual innocence. On a Sunday morning, Rook walked out of the Granite County Jail with his sister, carrying a single plastic bag containing the clothes he had worn to the hearing. The sky was overcast, the air heavy with the promise of rain. His sister drove him to her house in Harborview, a modest ranch-style home with a fenced yard where her children played. The drive took 6 hours, and they spoke little. Rook staring out the window at landscapes he had not seen in 20 years. New shopping centers where fields had been, highways widened and repaved, billboards advertising technologies he did not understand. At her house, Rook sat at the kitchen table, hands wrapped around a mug of coffee, and watched the morning light filter through the curtains. His sister showed him photos. Her wedding, a small ceremony in a garden, Paul standing beside her in a rented suit. Her children as infants, swaddled and sleeping. Her children now, gangly and shy, peeking around the corner to look at the uncle they had only known through letters and supervised visits in a visiting room. She showed him pictures of their mother's grave, a simple headstone in the Riverbend Memorial Cemetery, where she had been buried on a rainy afternoon 3 years earlier. Rook had filed a request to attend the funeral under escort, but it had been denied on grounds that he posed a security risk. The case made headlines, brief and clinical. Wrongful conviction overturned. After 2 decades, DNA and coercion, claims lead to release. The Riverbend Tribune ran a front-page story with a photograph of Rook on the courthouse steps, his face half in shadow. Advocacy groups cited it as evidence that recorded interrogations should be mandatory from the first moment of contact, that Brady obligations must be enforced rigorously, that DNA databases should be expanded to enable post-conviction comparisons. The National Registry of Exonerations added Rook's case to its database, cataloging it under false confession, Brady violation, and official misconduct. Detective Harbour retired quietly, his pension intact. He declined interview requests, issued no public statement, and moved to a small town 200 miles away. Prosecutor Slate issued a statement expressing respect for the judicial process and declining further comment on pending matters. The Granite County Sheriff's Department announced that it would implement new policies for interrogation recording and evidence disclosure, though the details remained vague. Rook found work at a warehouse on the outskirts of Harborview, stacking pallets and loading trucks. The rhythm was familiar, count, lift, repeat, and he preferred it to idleness. The supervisor, a man named Moss, asked few questions and paid in cash for the first 2 weeks until Rook's state identification and social security card were reissued. Rook worked the early shift, 6 a.m. to 2 p.m., and spent the afternoons walking through the city, relearning streets and landmarks. He attended therapy twice a week, court-mandated as part of his reintegration plan, and spoke little about the years inside. The therapist, a woman named Dr. Lyndon asked gentle questions and did not press when Rook fell silent. His sister invited him to Sunday dinners, and he came, sat with her children, helped with homework, fixed the fence gate when it sagged. Paul was quiet and kind, shook Rook's hand firmly, and included him in conversations about football and local politics without dwelling on the past. The children warmed to him slowly, the daughter more quickly than the son, who watched Rook with wary eyes for the first month, before finally asking if he wanted to play catch in the backyard. One evening, North called to tell him that the state had agreed to a compensation settlement, $50,000 per year of wrongful incarceration, a total of $1 million, minus attorney fees and taxes. The final amount after deductions would be approximately $625,000, paid in a lump sum within 90 days. Rook thanked her and hung up. The money felt abstract, unreal, like a number on a screen that could vanish with a keystroke. He deposited the check when it arrived, opened a savings account, and continued working at the warehouse. What mattered was the small things. The ability to walk outside without permission, to eat when he was hungry, to sleep without the sound of steel doors clanging shut. To sit in his sister's kitchen and watch the sunrise, golden and slow, through the window above the sink. To hear his niece laugh at something her brother said, a sound bright and unguarded. To stand in the backyard and feel rain on his face without someone ordering him inside. The case left scars on others too. Victor's family had believed that justice had been served, that Rook's conviction had given them closure. When the conviction was vacated, they issued a statement through their attorney, expressing anger and confusion, demanding that the investigation be reopened and that whoever killed Victor be held accountable. Victor's brother gave an interview to the Tribune, his voice shaking with emotion. "We thought it was over. We thought we could move on. Now we have to relive it all over again, and the man we thought was responsible is free." The Granite County Sheriff's Department assigned a new detective to the Victor homicide, a younger investigator named Frost, who reviewed the file with fresh eyes. Hayes was brought in for questioning, but he invoked his right to counsel and refused to speak. Without a confession, without the murder weapon, without witnesses, the case remained cold. Frost canvassed the neighborhood again, interviewed the security guard who had found the body, and tracked down the two bar patrons who had provided Hayes's alibi. Both were now deceased. Surveillance footage from the anchor, if it had ever existed, was long gone. The lessons emerged slowly, filtered through academic studies and policy debates. The Riverbend Tribune published an editorial calling for mandatory recording of all interrogations from the moment of first contact, not just after Miranda warnings. The State Bar Association convened a task force on wrongful convictions, issuing recommendations for improved discovery practices, expanded access to post-conviction DNA testing, and enhanced training for defense attorneys on false confession science. The Granite County Sheriff's Department adopted a new policy requiring audio and video recording of all interrogations, with exceptions only in exigent circumstances and subject to supervisory approval. But systemic change is slow, and the machinery of justice resists correction. For every case like Rook's, dozens more languish in appellate limbo, waiting for someone like Cedar to flag the file, for someone like North to take up the fight, for a judge like Keystone to have the courage to reverse a verdict 20 years old. The National Registry of Exonerations tracks the numbers. Since 1989, more than 3,000 exonerations nationwide, representing more than 25,000 years lost to wrongful imprisonment. Each case is a life interrupted, a family fractured, a truth delayed. Rook does not speak publicly about his case. He declined interview requests, avoided television cameras, told his story only once, in a deposition for a civil rights lawsuit he ultimately chose not to pursue. He lives quietly in a small apartment above a hardware store, works steadily, and visits his mother's grave every Sunday after dinner, placing fresh flowers on the headstone and standing in silence for a few minutes before walking back to his truck. He has no social media presence, no public profile, no desire to be the face of wrongful conviction advocacy. He told North once, in a phone call late at night, that he just wanted to be a person again, not a symbol or a cautionary tale. On the anniversary of his release, his sister baked a cake, chocolate his favorite, and gathered her children around the kitchen table. They sang, off-key and earnest, and Rook closed his eyes, let the sound wash over him, and made a wish he would not share. Later, after the children had gone to bed, his sister asked him what he thought about most during those 20 years. Rook was quiet for a long moment, then said, "I thought about walking out the door. Just that. Opening the door and walking out." In a storage annex in Granite County, a banker's box sits on a metal shelf, labeled with a case number and a name. Inside, 3 cassette tapes rest in plastic sleeves, their labels faded but still legible. The voices on those tapes, one tired, one insistent, tell a story of how truth can be buried under the weight of certainty, and how sometimes it takes decades for the earth to shift and reveal what was always there, waiting to be heard. The box will remain on that shelf, archived and catalogued, a record of what went wrong and what was finally made right. A reminder that justice delayed is not always justice denied, but that the cost of delay is measured in years and lives and losses that can never be fully recovered. If this story has shown you how fragile the line between guilt and innocence can be, consider sharing it or leaving a comment on what safeguards you believe are most important to prevent wrongful convictions.